This is a race for a Caddo District Judge to replace Judge Jeannette Garrett, who ascended to the Second Court of Appeal without opposition. So this is basically a special election to fill that seat on the district court bench. The winner will have to run again next year in 2014, when it's the year for judicial elections. Basically, all judges are up for re-election in 2014. District court judges serve a 6-year term. There are 7 judges on the district court. 11 from 3 judicial sub-districts. The city is, the parish is divided into 3, yeah, I was thinking of the parish is divided into 3 judicial sub-districts, so not everyone in the parish will vote in this election. This area will, because we are in that sub-district. So with that preface, this is one of those rare occasions where you get to be the judge. And you decide who gets to wear the robe. And it's something you need to think about and make sure you go vote, because you might be before one of these guys one day. Or someone you know might be before them. So that's why I'm always nice to judicial candidates. You never know. Do we have any questions from the audience? I've got some here. The first question, Ken, are we going to do opening statements?
Opening statements.
Okay. How long?
About 3 minutes each.
About 3 minutes each?
Yeah.
Did you flip a coin on who goes first?
No, I didn't.
Who goes first?
Who's on first?
Okay, Mike Miller. I got you, Carl. Mike, you want to do the opening statement?
Sure, that's fine.
3 minutes? Okay. Introduce yourself and tell
That's
us
what I was going to do. Everybody, my name is Mike Miller. I'm new to the political process. So many of y'all, both Brady and I are both brand new to this process. So I'll take this opportunity to introduce myself and give you a little background about where I came from and who I am. And during the questioning process, we'll get into more details about my positions and running for candidacy. I was born here in Shreveport. My father's Don Miller, my mother's Sarah Miller. I've got 2 older sisters and 2 younger brothers. I went to A.C. Steer, Broadmoor Junior High. Back when I went, it was called Junior High. And then I graduated from Burnett High School. Went to LSU in Shreveport, and then I got my law degree from Texas Wesleyan University in Fort Worth. My older sister, she's retired. I have one sister, she's a surgical ICU nurse at LSU. One of my brothers is a defense lawyer for a labor defense lawyer down in Baton Rouge. My other brother's a graphic artist. I'm married to my wife Pam, and I have 2 sons. One goes to Caddo Middle Magnet, the other one goes to Riverside. My work experience, apart from being an attorney for approximately 15 years, growing up, I bus tables, Louisiana Downs, I muck stalls, I worked for Marvin Lessman at Marvin's Garden, worked in the fields, and I bartended a number of years at Monsour's, Center Package Liquor, Center Orchard House, and then down in Baton Rouge, I worked for Gino's Italian Restaurant, and then I worked at 2 health clubs down there. I was down in Baton Rouge working on my 2nd degree. I was a communication speech major here at LSU, but I was thinking about being a history teacher. So I went down there, I took the LSAT with my brother. He went to law school. I took care of him while he's going to law school, and I worked and went to school. And I finally realized I needed to go to law school, and that's what brought me over to Fort Worth. I practiced with my father for about 12 years until he passed. We did general practice, mostly civil and domestic litigation. Rarely did I get any criminal work unless I was court appointed by the courts when they needed. The conflict panel didn't have enough funds, so I was court appointed and did some free work. The past several years I've been doing criminal practice with the 26th Judicial District Indigent Defenders Board for Bossier Webster Parish. I started practicing in front of Judge Stinson, and now I practice my cases in front of Judge Robinson. Personally, I want to let you know that I thank Lou and Ken for allowing me to come here and meet with y'all and speak with y'all. And I'll go ahead and table it to the specific questions that I'm sure each one of y'all want to propose to us. And I'll give Mr. Callaghan his time to introduce himself.
Ready?
Hi, I'm Brady O'Callaghan. I'm also running for District Judge. My wife Amy is here with me. We have two boys, Logan and Marshall, who are twin 7-year-olds at South Highland School, and I had a full head of hair when they were born. I went to Middle Magnet. I went to Magnet High here. I worked at Brookshire's over there on Kings Highway when I was in high school. I just found out today that the Madison Park El Chico, where I waited my first table, is closing its doors, for those of you who didn't see that in the news. Yeah, I'm sorry to be the bearer of bad news, don't blame the messenger. But it is closing its doors, but I waited tables there and did all the jobs, worked at LSU as a runner and all sorts of things there. And then I worked as a runner at Cook Yancey, a law firm here in Shreveport downtown. And having been a debater and a public speaker, while I was at Magnet, I won the state pro-life oratorical contest my senior year and some other awards for scholarships and whatnot. I thought that the law was probably where I wanted to head. I was lucky enough to be admitted to Yale University, and that's where I received my undergraduate degree in philosophy, and had enough of the Northeast, and I returned to LSU for law school. Got my degree from LSU and worked for a firm down in Baton Rouge for a few years in a general civil practice, handling everything from representing a fellow who bought a prosthetic leg and he had to have his leg amputated, and he didn't want to pay for it because it kept falling off at the grocery store. And so I represented him in city court. That was my first trial by myself, all the way up to $12 million federal litigation about a crane that fell into the Mississippi River that had 15 law firms from all over the state. That was interesting work and lucrative work, but it wasn't satisfying work. And my wife, who was then just my girlfriend, lived in New Orleans. And so I left Baton Rouge and went to New Orleans to join the DA's office there. And we got married. So that was the number one good thing. And number two good thing was that I found what I thought was, the direction I wanted my career path to take, which is public service. I served as an assistant district attorney for 2.5 years in New Orleans and rose to the rank of a senior homicide prosecutor, creating a special unit for following murders from the time they happened on the street, working with the police all the way through the trial. Amy and I didn't want to raise our family that we wanted to have in New Orleans. It just wasn't the environment we wanted them to be in. It wasn't the school system we wanted. So 10 years ago, I applied and was hired by Paul Carmouche to join the DA's office here in Shreveport, where I have worked for the last decade. I've worked for Paul, and who's supporting me, and I worked for Judge Scott, who's supporting me. I've risen to the ranks back again. I didn't get to start back as a senior homicide prosecutor. So I had to re-earn my spurs. And I am now a senior violent crimes prosecutor who handles some of the worst murders you may have heard about. If you remember Sergeant Tim Prunty being murdered, I prosecuted his killer. If you remember the Proc homicide out on Greenwood Spring Ridge Road where a fire captain was killed in front of his mother, I prosecuted and got the death sentence for his killer. Felton Dorsey, exactly. If you remember the home invasion north of town that Robert Coleman and Brandy Holmes did when they murdered a retired minister, shot his wife in the head, I put them both on death row. That's what I've been doing for the last 10 years, and I want to continue my service in helping victims of crime and our community as a district judge.
Okay, first question, both candidates have kind of touched on this, but what areas do you consider your judicial expertise, since the district court deals with a variety of issues? And I think certain judges are assigned to certain issues on the court. Mike, you want to go first?
And as I indicated earlier, my practice started out alongside my father. We did general practice. Most of it was domestic litigation, divorce, child custody, child support, and also did civil litigations, personal injury, probate, interdiction, property issues. Did some workers' comp, but that's not an area of law that the district court will handle. That's another area. Pretty much, my dad and I had a general practice, and anything that walked in the door, the people came to see us, and they needed our help. They didn't go down the street, they didn't go downtown to the big towers, they came to me. And they came, no matter what, needed my assistance, and so that's what we did. We helped the families in need, tried to make sure the law was applied fairly, and make a difference for them. And like I said, I didn't do any criminal work. I had a client whose son was caught with a joint, or somebody's daughter had it driving under the influence, and we would take those cases on. Apart from the cases that I was told to do free work for, that was court appointed by the courts. I wanted more criminal experience so I could present a total package. Someone who's had the experience from all the different areas of law. And I practice all across North Louisiana. I've had cases over Arcadia, down to Mansfield, Natchitoches, city court, district courts. And so I needed the criminal exposure, but those type of clients just never came in our door. And so I was offered a position to get that experience, and I guaranteed the chief defender at least 2 years of my time to give her someone who has trial experience to assist her with those people who can't afford competent representation. And that's what I've been doing the past couple of years with the Indigent office in Bossier. So I feel that with the all-around experience I have, plus with my life experience I bring with me, that I am an excellent choice to have the privilege to serve each and every one of you as your next district judge.
Brady?
Well, I would obviously, having been a DA for the last 10 years, I'd say that criminal law is my strongest area. I've done nearly 100 jury trials as a prosecutor. I've argued before our state Supreme Court on death penalty cases on at least 3 occasions that I'm positive of. And I've been in the Court of Appeals enough time that I kind of stopped keeping track. So I have handled some of the most complex legal issues that confront our community in criminal matters. I did have, of course, before becoming a DA, pretty extensive civil experience, as I told you, from the little stuff all the way up to the big stuff. And I have, as Mr. Miller said, when you have a client and they have some collateral issue, they want you to handle their divorce. They want you to handle that succession. So that's given me some exposure to those issues as well. But I think the question was the strongest area, and I would be lying if I said anything that my strongest area, certainly. I believe I'm competent in all areas of law, and anybody who says they know all the law is, I think, selling something. But I would say my strongest area is certainly the criminal law, and the judges choose which area based on the seniority. Right now, the judge that's filling Judge Garrett's seat, the temporary judge, is in a criminal section. That's where I think the elected judge would go. I think I'd serve well there, and if I was given the choice, if I achieved my seniority, at least for a while, I would continue to choose to serve in a criminal capacity, because that's what I do every day, serving the parish.
Okay, I guess you pretty much covered this, or what local judicial issues do you feel least qualified to address from the bench and best qualified? I think, very briefly, Brady, I think you pretty much covered that question.
Yeah, I would say, again, I don't think, civil law can be everything from a property dispute over where your property ends and your neighbor's begins, all the way to an oil and gas lease. So, that's a huge world of law, and no one knows that that's what lawyers are for, to tell judges what the law they think should apply in the case. I haven't done a million divorce cases, so I would say that if I were assigned to a domestic section, I'd have to bone up on that, because it's not something I do every day. But I think that having dealt with child victims of horrible crimes and worked with them on those issues, that I think child custody can't possibly be quite as horrible as that. So I'd like to think I could muddle through. And obviously, I think my strongest suit would be on the serious crime.
Mike, comment?
As I indicated, 12 years civil and domestic litigation. We handled many personal injury type cases, from medical malpractice to automobile accidents, slip and falls, whatever. Successions, probate, adoptions. I've done juvenile court, and I've done very little criminal except for the past several years, and I have accumulated a lot of experience in the criminal practice with my job working with the IDB office. So I feel that the area of law that would probably be my strongest would be, I don't know all the law. I've never done any bankruptcy, but we would never have to touch base with that in district court. But the one area of law that would be the hardest to serve on would be the domestic for me, because as a practitioner, in dealing with divorce, and dealing with custody of children, I know the emotional factor is elevated to an extent to where the law is easy, but you're dealing with people and their emotions and having to separate children from their parents either every other weekend. And that, to me, as a practitioner, was the most difficult area of the law. And a lot of judges would use mental health professionals to make recommendations, so they would, to help the court determine the custody of the children. Civil law encompasses a lot of issues that no attorney, like Mr. Callaghan said, knows it all. But it's more of a motion practice. It's more of a practice where you deal with a lot of hearings and arguments in front of the judge. And then the criminal law, to me, is a more easier area, as opposed to when I was as the plaintiff's attorney and I had to bring the case. As a defender, the case is brought on by the district attorney, and I have to represent my client to make sure their rights are maintained and that they have competent representation through the process. So all areas of law I'm comfortable in going into if I got the privilege of serving, but the one area that would be a tug on my heart would be on the domestic bench.
What issues of serving on the bench trouble you most and having to do with politically sticky issues? So I guess, in other words, what role do you see politics playing in your role as a district judge? Mike, you want to go first?
Well, politics shouldn't take a role in any capacity as a district judge. A judge, when the founding fathers formatted the separation of powers, they did the legislative, executive, judicial branch. The judicial branch is supposed to be less destructive. You can't make law, you can't get to just sit in judgment and apply the law. And so politics should not come into play, because a judge has to be independent, has to show integrity and confidence from the members of the community that they will be fair and impartial. And if you bring in politics, or if you're backed by the Trial Lawyers Association or the North Louisiana Defense Lawyers Association, that could lead to you as a citizens that judge is going to be favorable to the plaintiff or is going to be favorable to the defendants. The judge has to be independent and be apart from the political process. I know it's a process that we all have to take part in electing our next judge, but politics should be part in the legislative part, okay? That we send people down there to make the laws. The higher court, Supreme Court, applies and interprets the laws. I have to, if I've got the benefit of serving, apply the law as written. I can't not apply it, I can't make law, and I can't take away from it.
Okay. Great.
I agree. I mean, every jury trial that I've done, the judge reads an instruction that tells the jurors, passion, prejudice, sympathy, and fear of public opinion shall have no part in your deliberations. And that's a very important protection that every defendant has. I'm pretty proud of the fact that I almost never get objections from the other side when I'm arguing, because I'm careful not to make those appeals to improper things. I've had a lot of experience dealing with these kinds of experiences. There's nothing harder than telling the victim of a crime that you're not going to be able to prosecute the person that you sincerely believe killed their loved one because there's not enough evidence. And even though the word on the street, we know who did it, and maybe through things that we're not allowed to bring into court, we know who did it. When you stand up in front of a jury, none of that matters. What matters is, what does the Constitution allow you to present to prove them guilty beyond a reasonable doubt? And one of the hardest things I've ever had to do was tell a mother, ma'am, ethically, I cannot prosecute this young man because we don't have any witnesses. We just don't have any. And they won't testify, they won't cooperate, or they'll lie, whatever it may be. That's the toughest thing you have to do. And it would be very easy sometimes to go ahead and, well, we'll just throw up the case and see what happens. And that way we'll just tell her it's the jury's fault. But the problem is that ethically as a prosecutor, I've already had to answer the question that I'm not allowed to prosecute somebody unless I truly believe that probable cause exists to support the charge. And so I've already had to make and confront those tough decisions on a regular basis. And they are tough. They don't have places in a judge's deliberation. And I've experienced that as a prosecutor, and I think that experience would serve me well and give me the conviction to keep that kind of pressure out. You're going to hear it. So the question is, will you resist the temptation to give in to what's popular? And I've already had to resist that temptation on numerous occasions when I would rather not have.
And just an aside to that, we all watch TV shows, you know, like Law and Order, where you have attorneys objecting to what one of the attorneys is asking or doing. Does the judge have complete discretion in allowing the, you know, the testimony to go forward, or in sustaining the objection? I think that's always been something that's been kind of interesting.
Well, I mean, the rules of evidence are codified in Louisiana. We closely follow the federal rules, but not identically. So the judge is supposed to make all those determinations based on following the code of evidence. Now, I've had to actually take a writ, which is an emergency appeal, to the Second Circuit when I've disagreed with the judge's ruling. It's pretty tough because you're in the middle of a trial, there's a jury sitting there, and, well, Judge, I really want to ask this question. But as a general rule, the trial court is afforded wide discretion. So a judge needs to have a very intimate familiarity with the code of evidence, which is something I've been doing, on a regular basis. But yeah, they are bound by the code of evidence. The punchline, I think Mr. Miller would agree, is if it goes against the state, we can't appeal and not guilty. As a DA, that's been one thing. But if a defendant gets a bad evidentiary ruling from a judge, that would be a basis for them to seek an appeal.
Yeah, you got a comment, Mike, on that? It's
Brady was correct. That's correctly as he stated. The judge does make the determination, and it is based on the code of evidence. And if he makes a bad call, you can take it up on writs, and they can send it back down and tell them to correct it, and the trial can proceed. But it is a call that the judge does make, and they're not perfect. So there are many judges that are taken up on writs, but that is the correct response that Mr. Callaghan did present.
okay. And we'll move along here. We'll try to get out of here in the next 10 minutes or so. What judicial issues are most troubling as far as the MPC and the zoning board are concerned with regard to the district court?
What issues are more troublesome to the court with the NPC and
Yeah,
ZBA?
I guess, as far as the Metropolitan Planning
Yeah.
Commission and its rulings and all, does the court?
Well, my experience in presenting issues before the ZBA and the NPC, you go to one month, and wait the next month to go to the next hearing, then they pass it, and you have to go to the next month, so it's several process. I worked with a group of people investing in a piece of property, and they were trying to bring up the zoning to allow, it was zoned for like slaughterhouse, and they're trying to raise up the zoning so that you can add for apartments or, to bring it up. And we had to fight that for several months to get the zoning reapproved. Now, the district court, I believe, is set in place to rule on disputes. The ZBA and NPC is a governing body, and they should fall underneath the parameter and the control of the judgment of the court. And they shouldn't be, that's why we have the court system. So issues can go to the court when people have a dispute. It shouldn't be, I don't believe any one body should have complete autonomy to sit there and dictate on what should and should be zoned, how high the sign should go. They have certain covenants and ordinances and stuff to take place in that. But if there's an issue that needs to be presented, it should be allowed easily access into the district court.
Any comment?
Oh, my only comment is my experience with that has been timeliness. My biggest problem with that is that it's when things are in those administrative proceedings, people and my colleagues that have talked about these things are desperate to get in front of a judge because they want something they can take an appeal on. It's a lot easier if a judge makes a ruling, the process. You can go to the Second Circuit Court of Appeal, you can go to the Louisiana Supreme Court. And it's when it's kind of in the netherworld of administrative hearings that folks get the most frustrated, and when administrative bodies seem to frustrate getting a result from which somebody can seek meaningful relief. So that would be something that I think courts should never be activist, but I think that people should not be afraid to bring things to courts to get a definitive and clear ruling so that they have something, hey, if it's against them, they can take an appeal, go to work, go get an appeal, and if it's with them, then they have a decision, they can actually move forward with their business and their lives.
What's the difference and how does it work when you have a trial by judge and a trial by jury? Does the case dictate that, or does the prosecution or the defense dictate that? Brady, you want to comment on that?
In criminal proceedings and civil proceedings, it has to do with jurisdiction amount, and the person who wants a jury has to post a bond guaranteeing that they will cover the expenses of the jury. In criminal matters, it's the defendant's choice. The defendant can accept in a death penalty case. The defendant may waive their right to trial by jury and elect to be tried by the judge alone, in which case the judge is the final determiner of the law and of the facts. In all misdemeanor cases, with the exception of stalking and there's a little short list, but most misdemeanors are always tried to judges. But in felony cases, defendants have the choice. They have to exercise it now in a timely manner, because it used to be you'd have somebody set for trial, and the day it was their turn to go to trial, they'd say, well, I want a judge to try my case, and so they'd get passed off for that day because we already had a jury there, and they'd come back later. But the legislature has changed that. There's a constitutional amendment now. They have to announce it 45 days before their trial, but it is entirely up to the defendant unless it is a death penalty case, in which case they have to have a jury trial. And that's one of the reasons that having a judge who's experienced is important.
Yeah, comment?
That's correct. My experience has been in selecting in the civil matters, whether we have it before a judge or jury, it depends on the content of the issue and the knowledge of the judge. And if it's a complex issue, you want to present it in front of a jury, which they can sit there with confused faces throughout the trial, or do you want it in front of a judge who understands the process? And the criminal issue, it's up to my client. It's their choice what they want to do. I've had clients who wanted to have a bench trial because the jury trial, they're always placed on the bottom of the docket and their case isn't being heard. You can file a speedy trial or you can get hearing for the judge. My experience has been up in Bossier, in Benton area, is that if they're set on the criminal docket, the DAs, if they want to do a bench trial, the DAs will go, okay, we'll go ahead and allow it. And the judge will go, okay, if we don't pick a jury, you start your trial Wednesday instead of Monday. You see, so they don't postpone it and kick it back because they think, oh, well, I'll just postpone it a little bit longer. But no, the judges say, no, we'll start Monday, and then they kind of go, oh, wait a minute. And so it all depends on really the issues at hand and the judge and whether you want to present it in front of a jury or have a bench trial. And that's what I've experienced as far as a practitioner.
Just curious, how many of you in here have been called for jury duty or have actually served on a jury?
Wow.
Yeah, I got called 6 times in 5 years. But I never, made it to the jury box. I always got eliminated. We'll make this the last question, Ken. And when you knew this question would come up, it's kind of dealing with the city of Shreveport and the lawsuit that's before now on the situation with the mayor and the dog park. So I guess the question would be,
Who let the dogs out?
yeah, are judicial determinations required if it appears that the city charter does not specifically set forth what the rules are? Judge?
Before they answer that, I don't believe that they can answer that. I don't want to tell you what to do and whoever asked the question, but I don't believe that they can answer that.
I think they
It's
should.
something that's pending, and it's against the canons for them to answer that.
Okay, this is Judge Sheba Sims, by the way, from Shreveport City
Well, but if
Court.
you want them to answer it, yeah.
Thank you.
Well, I have a question to throw in place
Okay.
of that if you want one. In the area of which each of you, it appears that you have specialized, and will you have a predisposition to that if you were elected to judge?
First,
You want to go, Mike?
Oh, sure. I don't specialize, I never specialize in area. I mean, there's certain areas of law that you can receive a further education and get your, like in family law, there's several friends of mine who have received that. What I present is I have an experience across the board, and I try to get as much as I could in the period of 15 years that I've been practicing law. And so, as I indicated earlier, I'm comfortable, chances are the newbie judge coming in is not going to get the civil bench. Right now, like Judge Blatch is sitting ad hoc on the criminal bench, but when the election comes around and the placement is, one of the judges could jump off the domestic bench and want to go to the criminal bench, and now he's sitting on a domestic bench. And so the newbies don't know. They're coming in and they get whatever's left over. And so I'm comfortable in either the three areas, whether it be the drug division that Judge Marcotte's in, or the criminal section, whether it be domestic or even civil, which I know it's not going to be civil bench, but any of those areas of law I'm comfortable going into.
Great.
I think, Judge, you were worried about a predilection. I mean, I feel equally able to handle all of them. I've gone and handled enough domestic cases to wade through that and the heartache that involves, and I've got enough civil experience that I agree with Mr. Miller that, neither, the winner of this election will not be serving in the civil section. That's what the judges generally like, the ones that have been there a while. They tend to keep, yes, they're not going in. I would think that, one concern might be, hey, I've been a prosecutor for a long time. If I'm on the bench, am I just going to want to light everybody up? And my answer is no. I am supported by a lot of criminal defense attorneys because they know how I treat people. I take my duty to prosecute and prove my case very seriously as a prosecutor, so I think that has convinced them that I would take it equally seriously as a sitting judge. I also have the experience to know that not every 17-year-old kid who steals a lawnmower out of somebody's backyard, I mean, that's annoying, having something stolen out of your house, but not every 17-year-old kid who does something for the first time needs 2 years in prison to set them straight. There are alternatives and there are steps before that that we can work with them. And I've gotten a good relationship with a lot of people in the Caddo Bar because I'm reasonable, because I'm moderate, because I don't prejudge my cases. So I don't think that I would have that predilection, or I don't think any criminal defense attorneys would have been willing to endorse me. They would have run screaming. So.
And a follow-up on that, Ken, say you get to handle drug court, what is your philosophy? There's a lot of discussion going on these days about legalization of marijuana, reducing criminal penalties for marijuana. Do you have any preconceived opinions on that right now?
I want to interject again. I don't think they can answer that one, but they can if they want to.
I think there's edges. I agree. Now, did you want me to take this one?
Yeah,
first?
go ahead.
I don't wanna, I see exactly your concern. I would say that I think that any judge promises to follow the law. I think that there are things like Article 894 is a provision of our law that allows someone who gets their first misdemeanor conviction to take that conviction under special terms, and if they've completed probation successfully, get it removed from their record. That's something that DA's offices have often objected to, but judges have the power to do it whether the DA's office objects or not. Now, if that person gets in trouble again, messes up on probation, hey, it's right back on their record. But if they stay clean and don't mess up again, then when they apply for a job 5 years from now, maybe they can actually get a job and be productive because that's not on their record, depending on the case. But I do think that it would be imprudent to opine about the enforcement of an existing statute under the canons of judicial
Any
conduct.
comment on that, Mike?
That's correct. It's just basically, the law's the law. Either of us who get elected to this position has to apply the law. And there are provisions set forth in the law, the Code of Criminal Procedure, and that will give the district attorney and the defense, areas where they can work out agreements, and gives the court, discretion. But that's about as far as I will comment on it. But like Mr. Callaghan said, there are avenues that are in place that can assist in that part.
And this, Ken?
I just had about 3 parts to kind of sum it up. Roughly what percentage of jury trials you prosecuted as the prosecution would, or the defendant is convicted, and roughly the same for you? I guess it would kind of be the flip side of the coin. What percentage of those folks have you successfully defended with an acquittal? And that's the first. The second is, what can we do as judges, if anything, so that we don't have another Judge Walker or Judge Claville, or is that just bad judges? You know, I think the laws are there to prevent that, but the individuals didn't follow the law. And the third thing, the final thing is, win or lose, are you gonna run next year for the full 6 years?
Okay,
And you can take them in any order.
all right, you wanna go first on that one?
All right, the first question was, how many
How
criminal,
successful
What percentage
have you
roughly
been, yeah,
have you
in your case?
defended successfully to the verdict being an acquittal? Whether it was a judge or a jury?
well, the majority, I mean, I take on a lot of cases
Right.
in the indigent offenders. Majority of the cases don't go to trial, they're pled out, they're all made a plea offer from the DA, and they're probated or less reduced sentence.
I'm leaving those out, the ones that go to trial.
The ones that go to trial, in Bossier, it's on 50-50.
Okay.
In Caddo, the ones that I did was appointed to,
Well,
yeah, it's about 50-50.
yeah. Right?
Oh, what was the other parts of the question?
Oh, the second one, is there anything we can do to prevent another Judge Walker, Judge Claville?
Judges going bad?
It's unfortunate.
I don't know how you can prevent that, it's
That's what I'm saying.
the makeup of the person.
They were
you
punished
elect.
eventually, so.
Just have faith.
And then are
All
you
I can
gonna
say,
run
the
next
person
year?
you choose.
Are you gonna run next year, win or lose, in October?
Am I gonna win next year when I win?
Or you can run?
As far as success rate, since I've been in Caddo, my conviction rate has been somewhere between 93 and 98%. I don't.
Whoa.
It's pretty high. I've lost one murder trial since I've been here, and I've lost one serious sex offense trial, and most of the other, I've got, I think, 28 homicide convictions to offset that one that still keeps me up at night. And then I've got about 17 sex offense convictions to offset the one that keeps me up at night. And I remember the names of the acquittals a lot better than I remember the
Yeah,
convictions.
I guess you.
Now, in New Orleans, before I moved here, my conviction rate was lower. It was different. I was doing a lot of little dope cases. I'd say it was probably about 50-50. I don't know about all my bench trials, the little ones that I did for misdemeanors, because I'll be honest, I didn't keep track of that. As far as what to do, I do think that people are reluctant to call people out on things they do out of court. And what I mean by that is, you know, I've had a situation with a judge where I finally had to say on the record, Judge, I don't want to do anything else off the record. I don't want to have any more in chambers conferences. I don't feel like we're protecting a good record of what's actually happening in this case, because whenever we talk in chambers, which 9 times out of 10 with most judges is great, it was just not, when we got back into court, I felt like that wasn't ever getting translated. And so I think that lawyers and litigants need to, when something that happens outside of the record makes them uncomfortable, they need to speak up on the record, so it's in there. As far as the third question, yeah, I mean, obviously, a successful campaign, I would turn around and seek re-election, you know, and then, you know, the other alternative I'll worry about on October.
Final question, and I won't mention any names, but the question is, if I get arrested, can you get my bond reduced? Does the judge set the bond?
Yes.
The judge does set the bond. So, maybe so.
But it was started about $1 million.
You know, I always try to be an objective journalist before final statements. So let me just say, we have 2 quality people and 2 quality candidates running for this judgeship. So we are very fortunate in that regard. And I think whoever is elected will serve us well on the Caddo District Court.
Start with Brady.
Brady, final,
About 2 minutes.
about 2 minutes summation.
Well, I mean, I hope that, it's hard to say why vote for me, because ultimately, everybody wants the same thing out of a judge. They want somebody to make smart decisions, based on the law, based on the evidence, and they want them to be fair. Fair and honest, and how do you know? And, you know, there really is no way to know. The only thing I can tell you is that I have a very clear, transparent, that's a word we hear a lot in national politics, but I have a very transparent record. You know, almost every case I handle now ends up at the Louisiana Supreme Court, and most of them end up at the United States Supreme Court and are looked at by teams and teams of lawyers. And I've never had a successful complaint made against me. The only one I've ever had made against me was by a rapist that I convicted, and it was fun. So, you know, I've been subjected to that scrutiny. I've been fortunate enough to get some pretty important endorsements from folks that I've had the privilege of working with. I've been endorsed by Sheriff Steve Prater. I've worked a lot of cases with the Sheriff's Office. I've been endorsed by my boss, D.A. Charles Scott, and today I was endorsed by the Shreveport Police Officers Association. So the people that have worked with me side by side on a daily basis have been kind enough and humbled me enough to say that they think I would fulfill those criteria of being hardworking, honest, and fair. I've given Caddo Parish 10 years of dedicated service, and I want to keep doing that. And I think the best way for me to serve this community is to take the next step and become a district judge and do it from the bench. I hope you all give me that opportunity. Thank you.
Thank you, Brady. Mike?
I want to thank y'all for being here at this late hour. As I indicated, my experience as a practitioner in the areas of law that we've covered, I believe it gives me a well-rounded candidate to seek this election as district judge and to serve this community. I have endorsements from a lot of supporters. I didn't seek out, as I indicated, support endorsements from any trial law association or Northwest Defense Bar Association, because to me, I think the judge should be independent and not distracted with the potential of the citizens thinking that, as I indicated, oh, he's going to be pro-insurance bar or pro-defense bar or whatever. What I ask of you is go talk to your neighbors. Those are the ones who support me. Go talk to other attorneys that you know. Go ask them, what type of character is this man that's running for judge? Do you know Mike Miller? Go ask them, and they will tell you. That's all I ask, that you go out and find out yourself, because this 30, 40-minute, hour-long introduction of myself is not enough. You can get information through direct mail or push cards, but the real response that y'all need to get is from your friends and your family who actually know me, and who actually has worked with me, or I've worked for them as their attorney, and they will give you the best response. And I just ask for your consideration on October 19th in order that I have the privilege of serving each and every one of you in this parish.
Great.
Websites for both of you?
Brady for CaddoJudge.com.